Welcome to Free Thought Matters. I'm Laurie Gaylor.
And I'm Dan Barker. We are co-presidents of the Freedom from Religion Foundation, which produces this weekly talk show as an antidote to religion over the airwaves on Sundays.
FFRF is a national association of freethinkers, atheists and agnostics, and other secularists, which works as a state church watchdog to protect the constitutional principle of secular government. We invite you to join us in this vital work or ask for more information, including a copy of our newspaper, Free Thought Today, at ffrf.org.
Today, we're going to talk about threats to the separation of church and state and to reproductive rights by the current Supreme Court. Joining us is an expert on all of these issues, Linda Greenhouse. Linda Greenhouse is the Pulitzer Prize-winning reporter who covered the U.S. Supreme Court for the New York Times from 1978 to 2008. Her books include a biography of Justice Harry A. Blackmun. It's called Becoming Justice Blackmun. Before Roe v. Wade, Voices That Shaped the Abortion Debate Before the Supreme Court's Ruling, written with a colleague, as well as the U.S. Supreme Court, a very short introduction. The Burger Court and the Rise of the Judicial Right, and her latest book, Just a Journalist, Reflections on the Press, Life, and the Spaces Between, published by Harvard University Press in 2017. Linda is also president of the American Philosophical Society.
And Linda Greenhouse writes a biweekly column on the law and is the senior research scholar at Yale Law School. Linda has spoken in the past at FFRF's 2010 annual convention and will be receiving FFRF's Forward Award at our November 2021 National Convention in Boston. And it's a thrill to speak with you, Linda. Thank you for joining us and for all of your work and coverage of the Supreme Court and promotion of separation of church and state.
It's a pleasure to be here. I'm a faithful reader of Free Thought Today. I always learn from it, so I'm very happy to join.
Well, that's quite a compliment. So you have been covering the Supreme Court for 40 years, and that's a broad time, broad topic, but how has the Supreme Court changed on the separation of church and state over that time?
Well, I started covering the court in 1978. Warren Burger was Chief Justice. Nixon had appointed him and 3 other justices to the court. And it wasn't all that long after the Supreme Court school prayer rulings of the 1960s. So there was actually a great deal of pressure on the law regarding church and state. And this showed itself pretty early in my own tenure at the court. The first case that really got my attention was a case on the subject of the public display on public land of religious symbols. This was a case from Pawtucket, Rhode Island. Mm-hmm. And there was a Christmas tree and a reindeer and a Santa and various other stuff and on public land. And the question was, did this violate the Establishment Clause? And the court said, no, by the way, it didn't. And what was really interesting about that was that the newest justice at that time, Justice Sandra Day O'Connor, wrote a separate opinion that actually she expressed a view of the Establishment Clause that became very influential as the years went by. She proposed what she called an endorsement test. And that is the religious symbol is okay, the display is okay, as long as it wouldn't make a member of the community who didn't subscribe to that religious view or practice feel like an outsider, as long as it wasn't kind of destructive of a sense of community. Now, that's obviously in the eye of the beholder. And just to fast forward a little bit, we get from that to a decision in 2019 that upheld the display of a 40 feet high cross on public land in Maryland. So, something was launched in those days that has kind of carried us along into places where one would have actually been very surprised to learn that we were going to go. So we've had what I would call a regression from the notion of the secular state in public displays, in public preaching, you might say. A case a few years ago called Town of Greece that listeners might remember. This was a town that had a practice of starting every town meeting with a prayer from a member of the local clergy. It happened that all the local clergy were Christian, and it happened that a number of them felt free to give overtly Christological prayers. And two non-Christians complained about this, and they won in the lower courts. But it got to the Supreme Court, 5-4, and Justice Anthony Kennedy said, well, this is speech, and we're all grown-ups, and we all have to hear things occasionally that we don't like. So if you don't like this, just don't listen to it. That was the Supreme Court's expression of what the Establishment Clause stands for.
Of course, that ignores the endorsement test, doesn't it? Because it looks like the city is endorsing that message.
Yes, I mean, there's just a lot of inconsistencies here. And, just to sort of cut to the chase so we can go on to your other questions, I'm sure you have. What I've seen happen is the Establishment Clause has been all but effaced. I mean, it is hanging by a thread. And the Free Exercise Clause, the second of the two religion clauses of the First Amendment, has been elevated so that it kind of swamps everything else. We've seen a growing privileging of religion as against all other forms of expression at an accelerating pace in the last few years at the Supreme Court.
So before we talk about the past summer's decisions, and there were 3 very bad decisions from our point of view on religion and government, there was also, you had a very interesting column about 4 of the justices and their views during this era of the pandemic and COVID, and churches being asked to close for the public safety. And you wrote that the persistence of the Supreme Court's conservative justices in seeking to elevate religious interests over those of secular society has started. And could you briefly talk about that?
Yeah, there were a couple of cases that came brought by churches to the Supreme Court from local government orders that restricted their capacity. It didn't say they couldn't have anything, but it said they had to keep a low capacity for social distancing, and this wasn't good enough. So they came to the Supreme Court and they lost. Chief Justice Roberts joined the 4 more liberal justices against 4 dissents who basically, like, what part of public health don't you understand? And I found this startling because these came up as emergency orders to the court, where it's not required that the court say anything. It's not like a fully published decision that the court issues after it's had full briefing and public argument and all that. These were emergency orders, and all the court had to say to the churches was deny. And actually, that's all the majority intended to say. But the Chief Justice was prompted by a dissenting opinion by Justice Kavanaugh to explain himself and explain that there's such a thing as a public health crisis going on. And religion doesn't get a free pass from having to abide by the rules that apply to everybody else. And I'll just offer a footnote, or really an opening maybe to other things we want to talk about. There was a major decision in the Supreme Court back, and it's now almost a generation ago, Employment Division against Smith, in which the court said, interpreted the Free Exercise Clause to say you don't have a claim. Religion doesn't have a claim for an exemption from a law of general applicability unless religion can show that it was singled out for some prejudicial reason. That's the law of the land as far as the Free Exercise Clause goes, but there's been a huge workaround, a huge runaround. A federal law was passed, the Religious Freedom Restoration Act, and it has metastasized far beyond what the sort of naive pan-religious coalition envisioned when everybody supported it as a good government measure. And we seem to be stuck with it. And I think we'll be talking about it in terms of what happened this past summer at the court, but it's That's a real problem that Congress created.
Yeah, I think the Freedom from Religion Foundation was one of the very few organizations to oppose the Religious Freedom Restoration Act when that was passed in the 90s. But we were too small to have any influence, I'm afraid. But that does bring us to the past summer's decisions on religion by the U.S. Supreme Court and Chief Justice John Roberts' role in that. And can we talk briefly? I know there's a lot to cover, but about the very bad precedent that's been created.
Yes. So briefly, my view is that privileging religion is one of the projects of Chief Justice Roberts. He's got a few others, but this is one that really came to the fore this past summer with these three decisions. One of them upheld the Trump regulations that allow an employer for religious reasons, or this really knocked me for a loop, moral reasons, undefined moral reasons. If those two things are different, I don't know, often they are, to just opt out of providing contraception coverage as part of the employee health plan as required by the Affordable Care Act, Obamacare. And the Supreme Court said, hey, that's okay as a matter of administrative law. And this all grows out of the Hobby Lobby case back 7 or 8 years ago, in which the court interpreted the Religious Freedom Restoration Act to require the government to allow an opt-out for a company, a corporation that happened to be owned by a religious family. And they said, we don't want to do this because it will make us complicit in the sin of contraception as committed by our employees. So this was the so-called Little Sisters of the Poor case this summer. Then there was a case about something called a ministerial exception. Ministerial exception is a judge-made law. It's not statute. So for instance, imagine that a woman sued the Catholic Church for sex discrimination, saying, I want to be a priest. Well, obviously, the courts are not going to get involved with that. But what else are they not going to get involved with? And that was really the question for the court here. These were two fourth-grade teachers in religious schools, ordinary teachers. They taught the ordinary fourth-grade curriculum. They didn't have religious training. They both taught a required religion class out of a workbook, in other words, not out of their own heads. And one had a disability claim and one had an age discrimination claim. They were both fired. And the Supreme Court said, the ministerial exception applies to them too, because as employees in religious schools, they carry forward the religious mission of the school. And so it means that tens of thousands, if not more, of employees, mostly women, who teach in religious schools are deprived of the protections against all kinds of discrimination that Congress has mandated for all other workplaces. And we don't know how far this is going to extend. I mean, how about the football coach who likes to have a prayer with his team? I mean, is he exempt? How about the receptionist who answers the phone and presents herself to the public as the face of that school? We don't know. So that launched something.
So in other words, religion is going to get privileged and the Civil Rights Act is thrown out if it's a religious institution. Yeah. So we're going to have to take a break. We haven't gotten to the Espinoza case about a religious school, so we're going to take that after the break. And then also, Linda, we're going to ask you to talk about abortion rights and why you are warning that we are going to fast lose them.
Hi, I'm Ron Reagan, an unabashed atheist, and I'm alarmed by the intrusions of religion into our secular government. That's why I'm asking you to support the Freedom from Religion Foundation, the nation's largest and most effective association of atheists and agnostics, working to keep state and church separate, just like our founding fathers intended. Please support the Freedom from Religion Foundation. Ron Reagan, lifelong atheist, not afraid of burning in hell.
I'm Ken, and I'm an out-of-the-closet atheist. For me, it was never a choice whether to become an atheist or not. It was just more of a natural progression. I never had an aha moment or any precise moment in time where I decided to suddenly switch gears. I was raised in a somewhat religious environment. I was a pretty liberal Lutheran family, but it just seemed the more I grew and learned and basically matured, I just kept, looking at the person to the left of me and to the right of me, and, I couldn't believe more and more that, other people were actually believing this stuff, whereas I was, progressing into a mindset that this is entirely not true. And it was never, a decision for me. It was just a natural occurrence. And so I think of myself as a natural atheist if there ever was one.
And we're back with Free Thought Matters, continuing our conversation with the author and journalist, Linda Greenhouse, who is an expert on the U.S. Supreme Court and especially on Roe versus Wade.
And Dan, you wanted to ask a question first about...
What you were saying before the break, Linda, it seems to me that you might be suggesting that some of the justices currently might have an agenda.
Well, I think they do. I mean, it's not surprising that judges at their level have agendas about this, that, or the other thing. And there's certainly a critical mass of justices today who I think believe that the separation of church and state has been maintained too strictly. And they want to create more space for religious expression. I think that's pretty clear.
So we didn't get a chance to talk about one other case the Supreme Court handed down that affects separation of religion and government, the Espinoza case. Could you briefly talk about the import of that?
I actually, of the three religion cases that came down this past summer, I actually think this one, Espinoza, is the most important in terms of its implications. So this had to do with a law in Montana that provided a tuition tax credit for parents who wanted to send their children to private school, private and religious schools. The Montana Supreme Court said, no, our Constitution forbids public money from going to the coffers of religious schools, and the Supreme Court of Montana invalidated the entire program. The Supreme Court said that, well, that was wrong, and that anytime there's money being siphoned off to go to a private school, it must go also to a religious school on the same basis. This is really quite a radical change. The way the law had evolved, in my view, unfortunately, up to now, was that if you're giving a benefit to private schools, you may also give a benefit to religious schools, if you choose. Now they've turned may into must, and this was a tuition tax credit, but how about just flat old tuition? It really opens the door as a constitutional matter to funding of religious education, religious indoctrination by the taxpayers, whether the taxpayers want it or not, and really has implications that are going to play out in dramatic ways, I think, in the coming years.
And there was dissent on the court, strong dissent to that decision.
Yeah, I mean, Sonia Sotomayor and Justice Ruth Bader Ginsburg saw this coming. They saw it coming from a decision 2 or 3 years ago, written by Chief Justice Roberts, who said then that the playground of a church daycare center was entitled to the same state subsidy, was eligible for the same state subsidy for fixing up its playground as any other school and any other daycare center. And he said, all we're talking about here is playgrounds. And I remember reading that thinking, yeah, right. So it didn't take very long to move from playgrounds to, the basis of religious education. And that's going to keep going. I don't see anybody on the court today who's going to put a stop to it.
Yeah, so we have kind of grim topics here because we want to talk about the imperiled state of abortion rights at the Supreme Court level and other courts, and also why abortion rights is a state church issue. You've covered Roe versus Wade. You've analyzed it. You've debunked a lot of things about the anti-abortion movement. You've talked about how it's primarily a religious movement. What's at stake now?
Well, just to underscore what you just said, Laurie, the opposition to abortion is religion-based. And to the extent that public law endorses that stance of opposition and makes abortion harder, if not impossible, to get, that is a privileging of religion. But the Supreme Court has never been willing to acknowledge that. It's obvious to anybody. The only justice who ever was willing to call out that fact was Justice John Paul Stevens, and nobody joined him. So that's an argument that's kind of off the table. So why do I think abortion rights are imperiled? We have a majority on the court. Right now it's 5 whose attitude toward the right to abortion ranges from outright hostility, that is Justice Clarence Thomas, Sam Alito. The one who's a little bit more in doubt is the Chief Justice. I think if there were no political or other kinds of consequences, I think he would join a court that would overturn Roe against Wade, but it's complicated for him because he is Chief Justice and he has a lot of other balls in the air. And so he kind of bought the court some time this past summer. He gave a dispositive vote. He didn't write the main opinion, but a concurring opinion to strike down a Louisiana law that was identical to a Texas law that the court had struck down a few years ago that required doctors to have admitting privileges in local hospitals, knowing that the states passed these laws, knowing that it would cause clinics to close because doctors who perform abortions, A, don't need admitting privileges, and B, can't get admitting privileges. So the Chief Justice joined an opinion striking that down, but he wrote a separate opinion that really put a lot of things on the table, indicating that change was coming and that there was a lot of discomfort with the majority of the court with the most recent opinion, which had been a very strong opinion by Justice Stephen Breyer, that said, if the state is claiming the obstruction is for the purpose of women's health, you've got to look at what purpose it serves. Does it serve women's health or doesn't it? And you've got to balance the benefit against the burden on access to abortion. And the Chief Justice said, no, we don't do balancing. We don't. That's just the wrong approach. And it opened the door to cases that will certainly come where you just look at the obstruction and you say, well, that's not such an obstruction, or it doesn't apply to so many women, and things will be upheld that would not have been upheld otherwise.
So we only have a couple minutes left, but Linda, I wondered if you could comment on this unprecedented action by Mitch McConnell to block a Supreme Court nominee by President Obama, which got us into this pickle of basically Kavanaugh, Gorsuch on the Supreme Court. What can we do about this?
Well, we've got to vote, and people that care about this really have to get a Democratic Senate because that's where it's at. And Mitch McConnell, a very smart man, has said that he believes that of his entire political career, the thing he's most proud of was holding that seat open to be filled by Donald Trump. He thinks it's what led to Donald Trump's election, because the Republican base got fired up and they knew this vacancy was going to be sitting there for the new president to fill. And that's what got them to the polls. And actually, I think he's right. I think he's quite justified in claiming victory and saying he's very proud. So the challenge for those of us on the other side of the street is to make sure he doesn't get that kind of opportunity again.
So I have to say that the Freedom from Religion Foundation is a nonpartisan, apolitical group. We don't get involved in elections, but what happened with the blocking of that nomination was unprecedented of Merrick Garland. And do you see any way toward correcting this at all in terms of some people are talking about enlarging the court or they're talking about changes on the court?
Yeah, I mean, you could make the court bigger if there's a Democratic president and a Democratic Senate and you want to create more seats. I mean, that can all be done by legislation. The Constitution doesn't tell us how many seats there should be on the Supreme Court. But I think it would be much less complicated just to have a Democratic Senate and a Democratic president who could fill the inevitable vacancies that will occur. And, I wouldn't, I think it lets out a lot of steam, but I think it's not realistic to think that major structural changes are about to come on the Supreme Court.
Well, Democrat or Republican, if they would simply honor the First Amendment and true religious freedom and women's rights, whoever they are, our country would be in a better place.
I agree with you.
Well, we thank you so much, Linda, for joining us today and for all of your advocacy here and your commentary on the Supreme Court. And we have been delighted to be able to reprint some of your many New York Times op-eds in Free Thought today, but we depend on you for your commentary and really appreciate that you joined us today and everything you've done. And seeing you next year.
I depend on you too, okay.
And thank you for watching Free Thought Matters.
Because free thought matters.
Hi, I'm Steve Pinker. In my book, Enlightenment Now, I show that the world has become a better place as reason has been overcoming superstition and tribalism. But the values of the Enlightenment are under attack. That's why I'm a proud member of the Freedom from Religion Foundation, the nation's largest association of free thinkers working to keep state and church separate. Please join me in supporting the Freedom from Religion Foundation to ensure that our government is driven not by religion, but by reason.